What happens when I go to court for domestic violence matters? If someone is experiencing domestic violence, they can call police and report what is happening. If someone calls police, the police will come to the house to interview the family about what is happening. If there is a lot of shouting, yelling, screaming, or sounds of violence, sometimes a neighbour might call police, and they will then come to the house to interview the family about what is happening. If police are called because there is domestic violence, or because you are being violent to your partner or wife, you may need to go to court. Police will decide if they need to take out a domestic violence order application. In Queensland, this is called a DVO. In other states, it can be known as APVO, ADVO, FVIO. If police are not involved, a person can go to the court and make an application themselves. What is a DVO and what does it do? A DVO is a decision made by a magistrate that tells the person using violence that they need to stop being violent or abusive. This decision gives police the option to take further action if needed. The DVO is there to protect people named on the order from violence in the future. It can't change what has already happened. The person using violence is called the respondent. The person experiencing violence is called the aggrieved. DVO court is a closed court, which means only the people involved in the matter are allowed into the courtroom. People in the courtroom will include the respondent, the aggrieved, police prosecutor, the magistrate, an interpreter if needed, and a solicitor if needed. Someone will know if they need to go to court because police will come to their house and give them a paper telling them they need to be at court. The paper will have the date when they need to go to court and what has happened, resulting in them needing to go to court. If the person doesn't go to court, the magistrate may make a decision to put a DVO in place without the person putting forward their side of the story. The respondent is not allowed to take any other people into the courtroom. The aggrieved is able to take one support person into the courtroom. The court will provide an interpreter if needed. Usually, they will be on the phone. If police are taking out the order, the aggrieved doesn't have to go to court. If someone is making their own application, they will need to go to court and will be given the date when they lodge the domestic violence order application. If the magistrate makes a decision that a DVO is needed, they will decide what conditions need to be on the order to help keep the aggrieved person safe. All orders have the following conditions. The respondent needs to be of good behaviour and not commit domestic violence. Sometimes the magistrate will decide other conditions need to be added to help keep the aggrieved safe. Other conditions can include the respondent needs to move out of the house, the respondent cannot contact the aggrieved, the respondent cannot come near the aggrieved. Sometimes children and other family and friends will be named if they need to be protected. Usually, an order will be in place for 5 years. A DVO is not a criminal offence and won't affect your visa status. If an order is in place and the respondent continues to use violence or abuse, this is called a breach, and this is a criminal offence. This might affect someone's visa status, or the person may be sent back to their homeland. On the day the person goes to court, there are usually solicitors and support services for the person to speak with. If you need legal advice, you can also talk to someone from Legal Aid Queensland. There are other services you can speak with if you need assistance. Police 000, DV Connect 1800 811 811, 1800 Respect 1800 737 732. Local Services, DVAC, 4642 1354. Men's Line, 1800 600 636. Legal Aid Queensland, 1300 651 188. Task 4616 9700. Multiculture Australia, 4632 1466.